Sir, Bali sir. Hello.
Yes, ma'am.
Do we wait for another 3 minutes or could we start now?
It's okay, ma'am. No issues. I will wait.
Okay, okay, sir. Thank you.
Okay.
Hello. Good evening, all. Am I audible to you? Hello.
Yes, ma'am. You are
Yes,
audible.
ma'am.
Okay. Thank you. I think we can start our session. Knowledge, when protected and shared responsibly, becomes the foundation of innovation and progress. A very good evening to everyone. I am Dr. Sister Jisha Thomas, Assistant Professor, Department of Social Work, Price College of Science and Management. Today is the third day of our faculty development program on intellectual property rights. And we have been eagerly looking forward to the second session by our distinguished resource person, Dr. Balisamy, Assistant Professor, Global Arts and Science College, Europe. We are very confident that this session will greatly enrich our understanding of innovation and invention and provide the valuable insights into the practical aspects of IPR. With immense pleasure and respect, we extend a warm welcome to you, sir, and also take this opportunity to welcome all the faculty members and participants joining us for this webinar. Now, without further delay, I kindly invite Dr. Balisamy to take over the session.
Okay. Um, Good evening, everyone. I think it will be a great day for all of you. So let us continue the session. So yesterday we discussed about some of the basic fundamental concepts and as well as key pillars of IPR. And as well as we also discussed where we are actually misleaded or maybe misguided by the institutions or maybe by the society or maybe by the pressure what we are actually facing. So also we discussed what are all the basic areas we need to focus. So I already mentioned that IPR is a great tool. It's like an supercomputer. Okay, so now we are in the era of AI, artificial intelligence. So we all know there is in three stages of AI. One is ANI, AGI, and ASI. So ANI is artificial narrow intelligence, AGI is artificial general intelligence, and ASI is artificial super intelligence. So these chat GPT, these type of things are just now in the transformation stage of ANI to AGI. So if ASI will appear, definitely the worlds will turn around. So why I'm sharing this particular example is, see, this IPR also, it's equally valuable and equally having a huge amount of weightage equal to ASI, artificial superintelligence. Don't just think and treat it as a normal black and white mobile for just playing games, snake games, or maybe just making calls and messages. Try to think in a big picture. Then it will be highly beneficial for all of us. Not only for us, for our institution, for our society, for our nation also. Because IPR actually yesterday, someone, I think one of our participants rightly pointed out, it supports our Indian economy. Actually, the strength of a country was decided by the knowledge power what they actually have. Yesterday, we already discussed about the importance of manpower. See, population not alone can give you the power. Okay, how much knowledgeable they are. That's what actually make them more powerful. That's why even government also always insisted and repeatedly saying. So we try to provide an internet connection each and every corner of India. So that's what the major indicator which is says we are shared. So each and every part of our Indian nation have the equal opportunity to upskill their knowledge. Especially IPR is a main component which is directly playing a master game with your knowledge session. Okay, so how you are going to utilize the knowledge, how you are going to protect your ideas, protect your brainchild. So it's a nice word, it's your brainchild. How you are going to protect your brainchild and how you are going to make them grow. So these are all things actually we already discussed a lot on yesterday's session. So I don't want to go deeper on those areas again. Now it's time for us to move on to the next stage of IPR. So yesterday I stopped my session with this slide. So this is what the main slide, I think so, especially for ourselves as a faculty members. So as a college faculties, what we are going to do or what we need to do with this concept of IPR, how we are going to utilize this tremendous powerful tool to upskill our life and profession, not only for the institution. Okay, so even though it's going to support the institution also, but not only, don't try to limit your focus within your institution. Always think bigger. So my point, my perspective is, as a professor, you have multiple opportunities, n number of opportunities. There is no limitation at all. You have various types of opportunities to utilize this IPR in many ways. So yesterday we already discussed some few ways, right? So you can find any industry, find that problem, and you can come up with a solution, protect that solution through IPR. Then you can scale it or maybe commercialize it. So we already discussed all. So don't think that's all the actual opportunities. We have huge opportunities. Especially yesterday we start one more conversation about the power. So what is the actual power of a nation? Which is the most powerful power of a nation? It's not the economy, it's not the missile power, it's not the army, or it's not the cyber, or maybe the system infrastructure what they have. These are all not the actual true top power or best power of a nation. Also, yesterday, some of our participants rightly pointed out human power is the actual power. Why I'm insisting this again and again is, as a faculty, especially as a college faculty, we have a huge advantage, even frankly says unfair advantage. Not only a normal advantage, it's an unfair advantage. Because India is an highest population holding country, especially the youth population. That's why all countries are actually keen on India. So who is actually having the opportunity to utilize that youth population, the youth manpower? Definitely they can do anything. Companies may do that same thing, because companies recruiting the youth employees, they are actually make that employees to work for them. They utilize their creativities, their innovations, and their problem solving skills. So they simply convert their youth's energy into a money making source for those companies. We are not a company. We are all professors. We are all in the field of educational service. It's a service industry. But we also have the same amount of opportunities what the corporate companies actually enjoyed. That is our students. As a professor, you no need to imagine, you no need to create everything by your own. Okay. So why we need to do? We have such a huge manpower with us, such a young mindsets. They are actually can run much faster than us. So there is a generation gap. I know that, but it's not even a matter while we are discussing about the creativity and innovation or invention. Why we can't utilize them? Basically, what we will do, so we ask them to do some projects or maybe some assignments or maybe some small research works, and we try to incorporate those projects or research works as a journal. So we can publish any one journal on that on our name. That's what commonly actually happens. I know that. So for, even though nowadays I'm able to see the trend actually how it's actually move on. Even though the journals also become just a numbers, man. There is no research. There is no valid research. There is no valid outcomes, as well as there is no impact factors. Just try to copy paste somewhere else, and so they try to make it in the appropriate format which was required by the journal publishing company. So they just make it and they publish it. It's also just like become a number game. Again, it's also the same problem which comes from our mindset. So yesterday I already discussed a lot about it, so I don't want to go deeper. Here, just think deeper. We have huge amount of youth manpower in our hand with free of cost, free of time. So you no need to spend huge amount of energy, money, time. What you need to do, just you can explain that particular industry and explain that particular problem with your students and ask them to think on it. Ask them to come up with a solution. Even though you're just giving them assignments, right? Just make this as an assignment. Okay. Just they are copying something from internet, or maybe they are copying something from ChatGPT. It's not going to provide any meaningful value for the students and as well as the faculties. What they're going to gain, or what we're going to gain. So what are all the tasks we are asked them to do? It should be beneficial for both of us. Even though it says it's a win-win-win situation. First win for student, second win for faculty, the third win for the society. So it helps them to think deeper. So the problem-solving mentality, it will create it. So that's what the huge. So I will show you the upcoming slides. I will give you some practical example how actually I implement this particular concept in my own project ways. Okay. So these type of things definitely will produce an unimaginable results. In some cases, seriously, I admired by many of the students. They are came up with some such a creative ideas, which is highly worthwhile for patent registration and commercialization. Actually, I try to initiate it in our institution, but there is some other reasons. Still, the process is lagging. But I hope all institutions don't have issues like this. So, in case if you have any possibilities in your institution, or maybe you can do it in your personal way, you can do this concept in your own. There is no limitations at all. So, through this, students also can be beneficial. Actually, I personally placed. I don't want to mention the numbers because it sometimes it might be seems exaggerating the situation. So, a genuine amount of students in such big industries, they're not even attending any interviews. Through their approaches, through their findings, through their research, as well as some of the students actually registered, some of the students also already got the copyright for their actual results, not a patent right, because it will take too long and as well as it will be a little bit expensive. But actually, we work on it to reduce it because government providing some additional facilities for patent rights registration for students and startups. But still, we are working on. They have some copyrights. Through their copyrighted works, companies are recruiting them. They're ready to hire them in a good amount of, in a genuine amount of salary. So they also will be benefited immediately. Still, they have connection with me. So this is how we can build a genuine and as well as best relationship with our students. We can make them think, we can make them proceed, we can make them solve any problems, and as well as they also going to benefit it through them. We also going to benefit it. Okay, so the thing is, even before you initiate the things, I think most of you all already know about this CSR funding. So can anyone explain what is called CSR funding, please? Anyone?
CSR, sir.
Yes.
It's a corporate social responsibility, right?
Yes.
And actually, yes, for each company or any organization, yeah, basically the companies, certain percentage, I think 10% or something, it's
Okay.
have to keep their of the profit, or the 10% of the profit has to be contributed to the social welfare, for the like any other charitable or any other means of reaching out to the society. That's it's a kind of social concern for people, that from the organization, or that's a social responsibility.
Okay.
If,
As per the Companies Act of 2013, Schedule 7, it says that whatever 3 years average profit, 2% has to be contributed for the betterment of the society, well-being of the society. So that is corporate social responsibility. And it is made it mandatory for all the companies.
Okay.
yeah,
Yes, both of you rightly pointed. So companies are nowadays spending huge amount of money in the name of CSR, corporate social responsibility. Especially they are spending this CSR money, this CSR funding for some form of reformation works basically. But there is no standard instruction for the CSR fund expenditure procedure. If you need any funding, if you have some POC, or maybe if your student have some valid POC, the proof of concept, so with the POC, we can directly approach any of that particular industry who have such a huge amount on their CSR account, if you make them believe, or if you prove them this particular product or this particular service or this particular methodology will resolve the problem what was faced by that particular company or maybe the particular industry, definitely they are very interested to spend their CSR fund for you or for your institution. Basically what we do, we always fight for the UGC grant or ICSSR grant. That's what actually we are mostly did. So whenever we talk about funding, these are all the main two funding sources. Nowadays UGC actually not offering too much of financial support for research, but still ICSSR actually offering many opportunities to conduct research programs and many development activities. But whenever we talk about it, we only focus on ICSSR and UGC, but still CSR is an best source for getting a good amount of funding for our research. So as well as they provide and support also. So you are able to access the industry directly. You can access many data, real world informations. So there is many number of possibilities and opportunities we have. So let me show you the real case what actually we deal with. See, this is one of the collaborative project which I completed last year. So this collaborative project we tied up with Infosys. So Gobi Arts and Science College and Infosys, we joined together, we initiate one collaborative project. So this project was not initiated by Infosys. So that's what you need to keep it in your mind, my dear friends. So I got an opportunity to attend around 10 days FDP program in Infosys Mangalore campus. So after that program, I came up with some new idea. So actually they share many things. It's like global business perspective, how to train the students for facing this global demand requirements. Actually, that's what their core concept of that particular program. So the 10 days program was, seriously, it sounds very good for me. So after that program completed, so I start think about it. Then I came up with an approach for different department collaboration and as well as collaborating with Infosys. Even my institution also don't have any idea like that. Even they are not able to get the picture what I'm trying to do, but they simply believe on me because they trust. So I have some learning outcomes. So they simply allow me to proceed, even though they are not able to understand the things. So I simply wrote a mail to Infosys. So to the HR, directly I wrote a mail to HR. I straightly quoted. So from the 10 days FDP, so I have these set of ideas to implement it in my institution with these number of students, the final year PG students from various departments in our institution. So if you are interested, especially if Infosys is interested to support us, we are happy to make a collaboration with you. I simply wrote a professional mail to Infosys HR. I got a reply within 1 day. He also says he was very happy. So then I came to know that they also have some certain conditions to prove the government their FDPs was actually making real impact on the society. They also need the POC, proof of concept. Otherwise, they can't make the game for a long period. They definitely need a POC. So the next day, I got an approval mail from Infosys HR. So then he asked me to send the students' details and as well as actually this is what the document he asked me to prepare. So actually, we came up with 4 new software ideas. As usual, these ideas was not made by me. So each idea was created by each one student from that group. So we mix different departments: CS, IT, English, and MBA. So because I'm an MBA guy. So we collaborate each and every department. We make their final project as a collaborative project. Fortunately, my institution and as well as my university also gave us approval for it, because we are an autonomous institution. But even though we approached university before proceeding this, university also approved this particular process. So this is what the actual mind map what we executed. Seriously, it produced very good result for us. But unfortunately, the project was not completed because we already know the project time period is only 3.5 months to 4 months. So the task what we took, it's actually not, it need more time, because this is our first time. It's just a trial run. So, but even though the relationship what we made between Gobi Arts and Science College or Infosys, or especially as a faculty, we also need to remember, we need to make our position as strong as possible to be on that institution. Our role need to be stronger. Okay, just getting n number of patents or maybe n number of copyrights on our name, it's not only the enough credentials for us, for the institution to make us stick with that, right? So we need to make the strong anchor point. This is one of the sample anchor point for you. So if you are able to make any connections like this, even I think nowadays the NAC and the NBA and AIRF, actually there is too many accreditation bodies and ranking bodies out there. So if you just check their ranking criteria, the ranking fields or categories, what they are actually looking for, they also given huge amount of weightage for collaboration activities, collaborative activities. Even recently we have an NBA visit in our institution. They also seriously appreciate this particular activity. They also simply say, they never see any these type of activities in any other institutions. Okay, they might combine with any one industry, but they are not collaborate with different departments. That's what they say. So why I'm saying this, even actually, if we complete this particular project, definitely the Infosys HR manager says he's ready to support us through the CSR fund. But again, there is in some supportive issues. That's why we are not able to complete it. But why you can't do it? You can do it in your institution. If you want to step ahead further, you can collaborate with different institutions also. It's also 100% appreciable by all accreditation bodies. Okay, definitely it will make you it will create a great impact for your personal credential in that particular institution, or maybe where you want to work on. These are all the ways you can utilize these type of collaborative and this patent options. Definitely, if we complete this project, if we completed this any one of this project, definitely I will ask them to register for patents. Actually, that's what that's what the beginning mindset of what I have. But we can't complete it. But still, I never left this. Still, we have very few students. Still, the process was going on. Okay, so there's n number of possibilities are available as a faculty. This is only possible because I am in faculty. I'm a professor. If I'm not a professor, this is not possible for me. I can't directly discuss with Infosys. I can't directly access the students, as well as I can't make them to do what I want to do. Nothing going to be possible. Okay, so these are all the things become possible because I am a college faculty. I am a professor. I don't want to name myself as a faculty. I am a professor. Okay, so because of it, we can do anything. So in case in future, if you want to collaborate anything, you can decide whatever you want. You can collaborate within your different departments, or you can collaborate with different institutions, what you want. So actually collaborating with the institution, there is no boundaries. You can collaborate within your state, within the country, or maybe you can collaborate with any foreign institutions. Actually, presently I'm working on with the collaboration. I try to collaborate with two international universities. Actually, this year we are actually planning something different. So some of the institutions also, we approach some local institutions and as well as some international universities for our collaborations. It's different from MOUs. Keep it in your mind clearly, my dear friends. This is not an MOU. MOU is just a paper document. Mostly we use MOUs to exchange our students and exchange our faculties. Or maybe in some cases, you can utilize their lab facilities. So it's not going to produce any more best results from my perspective, or maybe from my point of view. I don't know about the actual story of your institutions, but again, it's also a simple name. It should not be a name shake activity. You can do many things. They also will be benefited. You also will be benefited. So you're going to lose. Just give a try. We are not going to lose anything, right? So this just an example for you, my dear student, my dear team, because I have many things like this. This is my personality. I will do different things. So there is n number of opportunities. You can do anything what you want. Okay. Even this is what the 2 books I authored. 2 books I already told you yesterday, right? So these 2 books are also funded by one institute. One is funded by one corporate company, and another one is funded by institution. So my entire research work is based on that. Okay. If there is an opportunity is available, why you can't utilize it? Actually, there is 3 types of works: smart work, hard work, and right work. That's what my own philosophy of work. So you don't need to be over smart. If you try to be over smart, definitely you will use some shortcuts. At the same time, if there is some easy way to accomplish the things, why you need to choose the hard path? Try to choose the right path in between the smart work and hard work. Then you can do anything what you want, which is beneficial for all of us. So this is my contact details. In case if you need any types of assistance or any types of support in your institutions or any collaboration activities or anything like that, you can feel free to contact me. So this is my contact number and email ID. My website is under construction. I think it will be get ready by end of this month. So if you want anything, you can feel free to contact me. Okay. Now we are in the key area. So I don't want to beat around the bush here no more. So let's directly dive into the core concept, because why I keep on pushing it at the last, because most of you already know this. Or in other words, the speakers who are all actually providing lectures or maybe workshops on IPR, they already given sufficient amount of explanation about these different types of IPR opportunities and trends. I already told you, gaining a knowledge about a particular thing won't produce any results for you, my dear friends. What you are going to do with that knowledge, definitely that's what makes you invisible. That's what actually producing an output for you. Okay. So I try to address the elephant in the room. Okay. So these are all the basic types of IPR. I think most of you already know about it, but I try to give it in some different perspective on it, even in the same way. Each and every IPR have some different set of requirements. What might be the primary requirement? What is the secondary requirement? So primary requirement, in the sense, you can't compromise on it. It's uncompromisable. Secondary requirement, it might be adjustable. So you don't need to fulfill the entire and each and every component of the secondary requirements. It's depend on the nature of your particular work. But whatever it might be, you should fulfill the primary requirement of that particular IPR field. So first one is copyrights. So mostly all of us know about copyrights. So you can get copyright for your books, articles, photos, videos, anything, music. So you can get copyrights. So expression of an idea, it should be your own brainchild. So you can't get an copyright for others' work, right? Even nowadays we are so actually we have many AI models to generate images, videos, audios. Even some other AI models are available where you can, once you give the lyrics of a song, so you don't need to give any other original song. You can write your own song. Just you write down the lyrics, and if you upload the lyrics even in multiple languages, in Tamil, Karnataka, Telugu, English, Hindi, any languages, you can upload your script. Actually, it will compose it as a song, you know. So what type of song you are looking for, what type of background music you are looking for. So actually, since the song, it actually composed the entire song. See, they also got amazed. Even it sounds good, not too bad. It's also continuously evolving. So if you did anything like that, it's not worthwhile for getting copyrights because it's not your brainchild. But you can get copyrights for your lyrics, but you can't get the copyrights for the entire song. Okay, that's what the primary thing, because we are going to, so however we are going to move on into the AI field, everything going to be generated by AI. The most of the AI generated contents are not valuable for getting any form of IPR protection. Still, actually, there is some other strong debates are going on. If anyone got IPR protection for their AI created content, it will be disqualified very soon, because the IPR cell also actually not too much aware about the AI content detection. Still, they also feel some amount of lagging. But they clearly stated they are actually working on. Definitely, if you get any IPR protection for AI generated contents, definitely it will be disqualified in future. Okay, so get into the story. So it's a primary thing. The secondary requirements, it should be originality. That's what we discussed as of now. So fixation, it should have some standard. So you can't change the thing based on the scenarios, based on the location, based on the environment. It should have some standard. For an best example, you tried, actually you came up with, you wrote some books. Okay, so you authored a book. The book might be in English language. So if you want to convert that particular book into your mother tongue, so you are actually approach anyone translator, or maybe you can work as a translator and you are start translating the entire book into a different language. Even though you might get a copyright for your English version, that English version copyrights won't applicable for your mother tongue language version. For your mother tongue language version, you need to get the copyrights once again. Okay, the copyrights won't be extended or not applicable for the byrighted versions of any one original version. Even though if you want to translate any one book or article from any other languages to your own language, it's also 100% copyright violation. Okay, so you need to get an 100% written approval from the author who holding the copyrights. Recently, I heard some news from our circle. So some of the researchers, I don't know, they are in PhD scholars or they are, I don't know what type of research they are actually committed in. Some of the researchers actually try to copy the articles from China and Korea, so which is in Chinese language and Korean language. They use Google Translator to translate that, but those particular those list of articles from Chinese language to English, and they are publishing those articles under their names in some of the reputed journals. Even the journals also don't know about it. They simply published. You know what happened? The Chinese original of author of that article actually issued. Later, the Korean author also came to know about it. The Korean researcher also came to know about it. he actually never should, but he leaves some rubbish comments about, especially about Indian or Indian researchers. It's 100% IPR violation. They can sue you. Definitely, you will face the consequences. Okay. So don't try to simply copy the content from any other copyrighted sources, even though it might be in any languages or any form. If you want to do any modification or if you want to make anything from it, definitely whatever it might be, you need to get a written approval or maybe any form of licensing approval from the person who is actually originally holding that copyrights. It might be the publishing company or might be the author. Okay, so you need to get that approval for anything. Just using that particular article as a reference, it's not an issue. But if you try to copy some of the chapters or some of the pages, definitely you need to do the legal approval from the authors, my dear friends. Otherwise, nowadays IPR become very serious among all over the world, because governments are becoming too much keen on it. Not only Indian government, the entire world government, even though the author is ready to leave that case, but those governments are very keen. They don't want to take that thing as simple. They are always serious. Nowadays, Japanese and Chinese governments are actually suing all around the world researchers. There is many serious cases actually going on, especially India and USA. They are actually suing against India and USA researchers. Most of the UK researchers also in that same circle. Okay, so it's our own responsibility to make it right. It's also everything comes from this IPR category. Okay, so investment, labor, contract. So these are all optional. You can choose which one is required for your own research process. So the next one is patents. So from the first day of the session onwards, we discussed about patents. So I think there is some. I'm sorry, my dear friends. Actually, it's a AI generated. Again, it's also an AI generated. I think somewhere it's actually something is missing. Okay, no issues. Let us proceed. No issues. Okay. For even okay, I would like to point it once again. Yesterday, while ma'am gives the feedback, so actually she shared his opinion. So in my PPT, I mentioned this particular PPT was copyrighted by me. So I think all of you able to see Professor Balu, all rights reserved, with a copyright symbol. It's not me. I actually uploaded this particular PPT to IPR cell and getting in copyrights. I never actually each and every so I try to make as much as PPTs I want, as well as I continuously modify those PPTs. Not only me, most of you. You can't get an copyright approval for each and every modification from that IPR cell. It's not possible. Then what is the purpose of putting these type of statements here? See, Supreme Court clearly stated, if any of the material which is labeled with the copyrights notes, even though the particular person was not registered under copyrights, he equally have the legal validation to claim for copyrights. Okay. So here I mentioned that note. So it will give an legal protection for me, even though I never registered copyrights. Okay, it's another one great advantage, especially in a teaching field, as a college faculty. We should know that whatever the material you prepared, add this note. Okay, under your name, even though you were not registered, it will give an legal protection for your work. If anyone has copied, just you can simply show it to anyone has tried to copy, or maybe anyone has tried to get the copyright before you. Definitely you can use this material as a proof. Now this webinar going to be my proof. I can simply share this webinar recordings or maybe webinar screenshots to the IPR cell, and as well as I will argue against the particular person who is actually trying to copy my thing. There is many things is actually available, my dear friends. Okay, so I don't want to make you overloaded. Just I try to keep the ground smooth and easy for all of us. So the second thing is patent. It should be invention. Yesterday we already discussed invention versus innovation. See, this is what the direct terminology which is stated in IPR law. What are all the things you want to get patent? It should be invention. It should not be an innovation. But some exceptional cases, innovations also can be accepted. That's we going to see the upcoming slides. Okay. So invention is the primary category which is required to get an patent rights. So what are all the secondary requirements? There should be some amount of novelty. You no need to reinvent the wheel, right? That's what the common what we call common term we used, right? So you no need to reinvent the wheel because it's already existed. Just changing something in that particular wheel is not an, you can't make it as a big breakthrough, right? But you can do something else. Even Michigan tires. I think most of you know about that particular tire manufacturing company, Mitchell. The Mitchell tires, they have around 230 patents. Actually, this is also in 1.5 years old data. I don't know at present how many patents they might have. They have around 230 plus patents for their tire structures. They are producing tires for various vehicles like two-wheelers, four-wheelers, tractors, and heavy-duty vehicles. So each and every tire design, what they actually came up with. Actually, they also are spending huge amount of time and money for the research to came up with the right texture on the tire. So each and every texture, what was designed by Mitchell, was patented. They are actually strongly protected their ideas. Okay. Even though if you are a company, you can survive among the competition only through IPR protection. So it should be some novelty. It should be have some functionality. Just like creating something, I just make it appeal good. So it's not a big thing. It should have some functionality. It should have some usability. It should benefit for anyone of this world. They might be an employer, or they might be a business owner, or might be a student, or might be in general public. In any cases, it should be beneficial for anyone. It should be industrially applicable. Industrial applications. That's what I repeatedly say. Your idea should be a scalable one. It should be commercialized, or maybe it should be a commercialized one. So otherwise, it's not going to be a valid one for registering patent. See, my dear friends, actually it sounds like very simple, but when you apply for the actual patent rights, so once your provisional application was completed, so within 12 months you need to, so I will show the process later. So within 12 months you need to present your complete patent to the patent officer. Definitely, you will definitely face very high hypothetical questions from them. So you can't face any questions what they raise, because this is the basic principle what they are actually need, what they are actually looking for. Definitely, they will cross question you in what way your innovation or your patent going to be beneficial for this society. If it is not beneficial, what is the purpose of finding, or what is the purpose of doing this particular innovation? What is the purpose of getting patent rights? They will simply raise any questions like that. In other cases, if any one of us already got patent rights, which is more or less similar with your theme, definitely they will hire a legal lawyer. They are also going to ask the same questions to you. Okay, so always think on the industrial application. It should be commercialized, it should be beneficial for the society, or it should be beneficial for the company, or it should be beneficial for you any other way. Think on problem solving mentality. So otherwise, if you have some idea, you don't know where that idea can be applicable, then just picture your idea, apply for the provisional application, then find that actual problem solution fit where your idea can be fit properly. We can do it in a reverse versa also, no issues. But it should be applicable for industrial purpose or maybe for commercialization. So the third thing is trademark. So it's a protection for a business. So you can trademark your business names. You can trademark. Actually, there is two types of trademarks are available. So one is name, and another one is logo or symbol. Okay. So especially, wait, let me show you. Okay. Here, I hope you are able to see my. So you are able to see my mouse. So the smart revaluation, design your day. This is one of my brand, which is protected by IPR. So as well as those two books was protected by again IPR. So this I use trademark. This is my trademark. So no one copied it. So those two books are protected by copyrights. So actually, the reason why I'm explaining this, I will tell you. Actually, getting in patents and copyrights have some certain limitations, especially while we are dealing with trademarks and patents. There is some certain limitations are there. So we need to be make sure, or we need to be aware. We should be aware before getting into the actual story of it. Okay. So trademark will help to protect your business identity. So your business name, excuse me. Sorry for the interruption, my dear friends. Okay. So here under trademark, so you can trademark your name or your logo. So smart revaluation, I register it as a logo. It's as a imagerial or symbolic representation of my business. So you can get two types of protection from it. So yesterday ma'am says Achi Masala. Achi Masala have both. They have their name trademark, the text-based trademark, and as well as their logo-based trademark. Unfortunately, I'm not able to get the text-based trademark because my company have the word called smart. So it's a highly competitive and repeatedly used word among business industries, especially in tech. So that's why I'm not able to get it. But it gives a legal protection for us. Okay. So it should be distinguished, it should be unique. So VADA diagram, so both can be. So that's called trademark. Trade secrets. So yesterday we also discussed about the trade secrets of Coca-Cola and KFC. Can anyone tell me what is the trade secret of KFC? What we discussed yesterday? Anyone? I think it might sounds like classroom. So just the faculty asking what we discussed yesterday.
Sir, I think the ingredients are not revealed to everyone.
Okay, good man, good. Thanks for your remembrance. Actually, it's 16 herbs and spices.
Yeah.
That's what we discussed. Okay. So that's the
Yes.
actual trade. That's the actual trade secret of KFC, which is make it as a big world over franchise industry. Okay. So the same way, Coca-Cola also maintaining their trade secrets, and so that's what the actual core basement of that particular company. Without the trade secret, they can't survive for a long time. It will make the competitors too easy to take over for them. Take over them. So trade secret, it should be some form of information or procedure or any other specific thing. Especially it's an information or a combination or in procedure. They have many things. So that's a unique process which actually makes you a business. That's called a trademark. So here, the information should be confidential. It should be trustworthy. Okay. Just for an example, just adding some small pinch of salt in any one existing dish, so can be enhance the flavor, but it can't be considered as a trade secret, right? But even though here also you are using some form of different ingredient, so you may use some iodine salt, or maybe you can use some Himalaya salt, or you can use any type of salt what you want, but you can't name it as a trade secret. It should be a complete formula which is actually seriously producing a different weight output for you. Okay, so it should not be existed in the already available market area. Those things only can be valuable or worthy to consider as a trade secret. Okay, so otherwise nothing can be equal to find the point of trade secret. So actually next I'm going to discuss about the procedure, how the pattern was actually processed. So as of now, if any one of you have any questions, you can feel free to ask. So anything if you want to ask or anything you want to share, you can tell me please. Okay, so now the time is 7. So I just take 5 minutes break. We will join back sharply on 7:05. Okay, just 5 minutes.
Okay, sir.
Yes, thank you.
Okay, sir.
Okay. So I think let's we continue the session. Okay.
Yes,
So
sir.
these are all the basic types of IPR. So now this is the actual process how the patent was proceed under the IPR set, under IPR. First, you should have some idea which is worthwhile to consider for patent. Okay. First, you should have some idea, then try to do some ground research about that particular idea. Ground research in the sense you need to check whether there is any previous patents or applied for these type of similar models or concepts or anything like that. So there is, I think the day one, ma'am already explained where, what are all the places are available, what are all the websites are available to check the existing patents. So you need to check those types of patterns. So before getting into the concept, actually, ma'am already, the first day, ma'am also mentioned there is two types of IPR proceedings are available. One is national and another one is international. If you are getting an IPR protection under India, your IPR license can be only valid within India. You can't control your product or service maybe with your license for any other foreign countries. It's not possible at all. If you want to protect your idea throughout the world, then you need to get an international IPR license. Then only it will be valuable for all over the world, or maybe for any countries. So in this case, I have some practical, I have some real problem actually I faced. So actually, we are creating different types of productivity related products under our brand called Smart Revaluation. So even though I haven't registered trademark, so Smart Revaluation, we also created very different types of productivity products. So it's like annual planners, table planners, like that. So I am the creator of that particular product. Actually, we create and we sell through different online platforms, and as well as we have our own e-commerce site. Recently, we came to know that it's not recently, around 7 months before, we came to know that one of the manufacturers from USA, he simply copied my products, still with my name. He not even edited anything. He simply, I don't know how he able to get my product. He simply duplicated the product. Now my product is selling in USA. I know that. Actually, he is making huge amount of profit from it. I'm able to see the sales rating and as well as the total movement of that particular product. Actually, he is selling in USA. I'm selling in India. So I can't sell US from here because the warehouse cost and as well as the shipping cost is not affordable for that particular product. It will become too much expensive for that particular product. So it's not going to be profitable. But even though as a creator, as a business owner, I'm able to see someone is simply copying my business front of my eyes. I can't do anything without the international copyrights, international IPR protection. Actually, when I start this, I never imagined someone going to copy my business idea and business name like this from one of the foreign country. But it's actually happened. So still, actually, I have an hallucination in my mind whether I need to go to I need to get an international IPR approval, or maybe still I can just leave it and I can stick on with Indian approval, because international approval become too much expensive, and as well as the proceedings is too high. Even though I get an international approval, it's not going to give any types of beneficial to me, because I can't commercialize my product outside the India, because the production scale need to be highly increased. So it's actually not that much mandatory for me. That's why I keep on hallucinating between the Indian patent rights and the international patent rights. But so as a creator, you need to decide, as well as you need to be aware first. the difference between international and Indian patent rights. Not only India, each and every country have their own patent rights laws. Okay, some of them they may have. Yesterday we already discussed. We also discussed about the Shark Tank show, right? So in Australia, they only have Australian patent rights. So if anyone copy that particular product from China or USA or Canada, they can't sue them. Okay, so it's little bit easy and as well as financially affordable for the creator. So that's why we try to protect our ideas through these type of domestic protections, legal frameworks. So always keep it in your mind. So whether you are going to go ahead with the domestic licensing or maybe international licensing, so it's your responsibility to decide whether you are getting in copyrights, whether you are getting in trademark or maybe a patent, whatever it might be. It's your own responsibility or it's your own judgmental to decide which one you are going to prefer to. Okay, so now let me enter into the actual procedure of applying patent. First, you need to come up with an idea, and as well as that idea should be worthwhile for patent. Once you got the idea, then you need to do the basic ground search. So whether any similar types of ideas are already patented. So again, I repeated, check Indian and international patents. Don't only focus on Indian patent. Just you may think I already checked the Indian patent portal. There is nothing like that. So I'm going to apply this product or maybe this service as my own patent. You don't know. There may be someone who is from sitting in different country or in another corner of the world. They might have already international patent on it. They will definitely will sue you. So they can't legally sue you, but they can make your application rejected. So your entire process is going to be waste. Nearly it will take around 2 years for you to get into the stage. 12 months plus 18 months. It's 3 years. Sorry. It's 3 years for you to getting into the stage. At that moment, you came to know that, or maybe the researcher came to know that if they file in claims against your publication, definitely the IPR cell will reject your application. So your 3 years effort, 3 years research, 3 years energy, money, everything going to be meaningless. You need to start everything from the scratch again. So before initiating the process, check the international patent registry portals and as well as the domestic patent registry portals. Okay, so don't proceed without doing this. Nowadays, actually, there is too many agencies are available. Basically, who are all applying the patent. If your institution already have an existing functional patent cell, mostly they will help you to do this process. Otherwise, if you are an solopreneur, so they mostly approach any agencies. The agency will do this research for you. But as a faculty, we already know about the concepts. Maybe the normal layman, they don't know about these type of background functionalities and requirements. But we know that, right? So though we can do that agency task by ourselves. So search for it. Regressive search, not just formal search. Okay, search deeply, then list down the similar patents and their approvals. If your idea or concept is mostly similar with them, around 30%, then think twice. So whether I can modify anything in my particular application, in my model, can we make it more different from the existing one? What is the USP, unique selling point? So how you are going to make it different? So you need to think again and again, and you need to come up with the different types of alterations in your existing business idea or maybe the patent idea. Then finally, once you feel satisfied, you don't need to satisfy others first. First, you need to feel satisfied. Once you feel satisfied, I'm happy. I have an 100% confident my product or my service, my patented application is 100% different from the existing one. Then proceed with the provisional application. Provisional application in the sense, it just getting an token advance. It not mean your seat was reserved, but it will equally considered to be valid as a token advance. You are giving some token. You are registered first. You don't know whether someone in a, excuse me. Okay. You may know that, you may don't know. So how the Edison was invented the light bulb. So we already discussed that story, right? You don't know who are all actually working in the same field. They might register their patent before you complete your entire process. In those cases, you will be under trouble. So in especially when Elon Musk actually announced, so he is looking for some form of different solution for batteries. So as well as he mentioned, who are all actually came up with a new battery idea. So he's ready to give a huge amount of fund, huge amount of money for them to develop their product. Any one startup company, whether they are in solopreneur or maybe they are only 2 members in the team, it's not even a matter. If they came up with a valuable idea for a new battery, Elon Musk ready to spend huge amount for him for the developing their company to supply for the globe. So when he was announced, you know what happens? That particular moment, through over the world, the provisional application count was immediately raised because they know that finding the concept is not a big thing. I need to protect it first. Immediately they file a provisional application. Who knows? Someone else also have the same idea. But if you apply the provisional application earlier, definitely the legal formalities, the legal proceedings will support you. Okay. But in this case, you no need to complete the entire product or service. So first you need to file the provisional application. So then you need to develop the complete product or prototype or maybe the POC. You need to prepare the entire documents within 1 year, within 12 months. Okay. Then you need to present it to the controller or maybe the officer. Okay. In meanwhile, here they mention some few steps. Develop the idea, present the idea in the conference, publish it in journals. So my dear friends, so in these 3 steps, you need to be very clear. You should not completely disclose the entire story of your patent. It's such a meaningless activity. Okay, don't simply share your entire thing on any journals or any publications or any conference. You don't know who is the person actually listening your conference or listening your videos or audios. They might triggered by your idea. They can do it immediately. They might have their technical and financial supports. If you have any idea to get a patent, don't disclose that particular patent related idea in any of the journals or any of the conferences. Even hold your publications. Don't publish any papers which is going to reveal the thing what you're going to get patent. Don't publish any papers on that particular title or maybe on the particular concept. It will make you trouble. We don't know what might happen. Even in this case, I would like to I would like to give another one real example which was faced by my friend. Actually, he tried to publish one article. Actually, the article was completely written by him. He never copied anything. But when he tried to publish that particular article in one reputed journal, the journal rejected his article. You know what the journal says? This article is a copied article. He was getting shocked. He actually who is the person who wrote that complete article? It's a long period of research work. He not even able to digest that statement. He again argue with the journal, the company. The company simply share another one link for him, which is another one journal, another one article link. his entire article was published over there in someone else's name. He simply don't know what was happened, how his article was completely leaked, as well as even without having any change of any single word. His entire article was already published in another one journal and some other foreigner name. He totally get confused. Then finally we actually work on it. Then we came to know that he used some of the online converters. Actually, he have some Word document. He used one online PDF converter from Word to PDF. He upload his document to the particular website and he converted it as a PDF. Then he forward that PDF to this particular journal. But the conversion website who is actually offering that functionality, he is a culprit. Actually, that particular platform is in black sheep. Who is actually did this cheap thing to him? So unfortunately, he never applied for the copyright for this article, so he can't claim anything. His entire research work was become useless. So finally, I suggest him to rewrite that article in a different perspective, or maybe rephrase, paraphrasing. So I asked him to do that. So actually, we sit together and we did that work. So again, I asked him to get the copyrights first before submitting into the journal publishing company. So that's what he did. Finally, he published, but it's again took another 4 months for him to complete. So we no need to do that, right? So what all the ideas you have, first try to protect it first. Then you can publish it. Then you can showcase it. Okay. So that's all the thing you need to do. After the provisional application was once filed, within 12 months, you need to came up with the complete POC or prototype or working model to the examiner or maybe to the IPR officer, and you need to present it to them. There, once they feel your product or your service is valuable for considering patent, then they will allot you with some experts, because your product or service might have different types of functionalities. It might be engineering, it might be botany, or it might be geology, or maybe you have some business concept, because that's what we are going to see next. There is too many patent types are available. Each and every one patent type have some unique functionalities and unique nature. So you can't compare one type of patent with another patent. So each patent should have required some unique expertise. So they will ask you to move on to the expert process. Then he will examine your product or your service, what you actually developed. Once he feel, or maybe the officer feel satisfied, then the patent process will be initiated. Okay. So actually what will happen, once the officer feels satisfied, he allow you to publish this patent application, the complete patent, in their publication. Then only you are able to publish. So the officer should satisfy, the expert should feel satisfied, both of them satisfied, or otherwise they will ask you to modify something, or maybe they ask some other additional details. You need to do that process again and again to make them until they make them satisfied. Until their satisfaction, they won't allow you to publish in their publications. So once they feel satisfied, they will allow you to publish, not a normal journal, in their actual portal. So they will publish it for you. So once they publish, again it will took another I think this is it's 10 to 18 months. I'm not sure about that timing. Some of them says it's only 3 months, because my process is still in between. So even the IPR department also have some confusion about it. So they also don't have the complete clear picture. So but basically we know about the government departments, right? So I don't want to blame the entire government. So some of the government employees. So even though there is some proper legal framework for it, So some of the applications should be processed within 1 month or within 1.5 months. So however, they are not going to follow the same instructed timelines. So it will take their own time. Even a normal application, which is systemized application, it also take more time than they promised. So these type of applications for pattern, it's an 100% creative and mind-oriented applications. So you can't make them strictly follow the timeline. So that's what the legal team also can't do anything. So that's why there is no fixed time frames what we may expect from it. It might take. So if we are lucky, it will proceed faster. In other cases, it will take as much as time what it actually requires. Okay. So once the article was published, so it will publish to the entire India or maybe to the entire world. So the other patent rights holders or maybe the other passionators of patent, they will look on it. So if they feel your product or service is similar with their product or service or POC, they will file an appeal against your application. So they also need to appeal within 3 months. That's what the actual protocol. But nowadays they are actually allow the appealers to appeal even after 8 months also. This also happened. So we have some case studies also. But let's see how long we can proceed. Okay. So once the particular pattern was published, you have some time. You need to wait for some time. So if there is no appeals was raised, then the patent body will approve your patent. If anyone has raised any appeal, it's your responsibility to give a justification, or maybe it's your responsibility to do the required alteration in your patent application. Again, the process will start from the scratch. Okay, this is what the actual process of the patent application. Approximately, it will took minimum 2.5 years to 3 years, basically. The casting of this application is vary based on different stages. So if you are a student, if you are a startup, or maybe if you are a registered MSME student, or if you are a registered company within SIPCAT, so each and every, or maybe if you are running your business in the economic zone which was allotted by the central government or state government, each and every criteria will affect the actual fees procedure of your applications. Okay, so it's also continuously switching in different scenarios. So you need to search first before proceeding any application. These are all the principles, these are all the concepts you need to keep it in mind. So I'm just forwarding my patent application right now. So keep your mind open. So it might take around 1.5 years or 2 years. You need to be passionate. You need to be ready to wait for the complete process. Then proceed the things. Don't try to do it in a hurry-burry mindset, because definitely it will take time. Okay. So anyone have any questions? Any questions as of now?
No, sir.
No, sir. No, sir.
Okay.
Going well.
Okay. Thank you.
No question, sir.
Okay. Thank you. So this is the same process applicable for a business pattern also. So on the day one, I think some of our participants asked about the business patterns. So if I have any business idea as a business professor, so there is any possibility for me to get pattern for my business idea? Because these patterns are mostly applicable for engineering or maybe science backgrounds only. So it's nothing like that. As a business professor, so if you have any one business model which is truly producing in valuable results for any one of the industry or any one of the business, it might be financial, operational, functional, sales, or in any other ways. If your idea is unique and as well as it's patentable, then definitely you can proceed with the same process. This is the same protocol in a different picturization, different infographic style. Business model also will fall under the same procedural activity. It also will take the same time durations. Okay, so there is no huge amount of difference between normal engineering pattern and business pattern. Both will take the same duration, but The documentation wise, your preparation might be different. The requirement might be different. Or for an example, if you are actually trying to invent new machinery or a new form of some device, just you can create a prototype and you can show it to the examiner. Then you can explain this is what the device, this is how actually it's functioning. Just showing the actual demo of that particular device, it's enough for the engineering people. But if you are a business professor, you want to get a patent for your business model or maybe the business idea, so you need some different form of POCs. It requires some real experiments among some different industries or maybe with some genuine amount of participants. Then only that particular concept can be acceptable. Still, the IPR officers are not too much aware about business concepts. So definitely it will be a highly challenging scenario for a business professor who is actually came up with a new business idea for patents. But still you can get it with your strong ground study. Okay. So you need to be strong on the concepts what we discussed as of now. If you strong on it, definitely you will get patent. No issues. Actually, one of my friends, actually myself and three of my friends actually applied for one business model patent rights. Actually, it's in the publication stage. Actually, it still remains in the publication stage for last 4 months. But still now it's not published. It's in the stage of publishing, but still now not yet published. So we also don't know when they are going to publish it and how long it's going to take. But we already cross over the examination stage and as well as the expert stage. So the same thing we faced. So I am the person who is actually arguing with that examiner and expert. We actually make them, we actually prove our concept is actually working. It's actually functional model, which is definitely producing a result, as well as we have a strong sample, which is clearly stated it's highly effective. Because of our sample, because of our strong research, they can't hold us. But even though the process was hold because of the normal timeline. Okay. So how many of you notice these type of symbols? Excuse me. So how many of you notice these type of symbols in any materials? Anyone notice these type of symbols?
Not really, sir.
Okay. Okay, fine.
Is it on a
So-
product, sir?
Sorry?
Is it on a product or a
It's a
behavior?
so these type of symbols are basically used in creative documents, especially in copyrighted materials.
Okay.
For an example, in our old days, we get CDs like music albums in a CD or DVD. So
Yes.
in those types, we get those type of disc, right? So if you're
Yes.
on the backside of the particular CD disc or maybe the CD pouch, you are able to see these type of symbols. Nowadays, it's a little bit rare, but still it's actually functional. Some of the countries make it 100% mandatory, but according to Indian norm also it's mandatory, but most of them are not following it properly. So this is actually a copyright notification symbol, which is try to explain what type of copyright protection was held by the owner of the particular product. If symphony or any other music industry, they came up with some new songs or new compositions, they might publish it as in CD with any one of this symbol. Each and every symbol have some different meanings. If you want to publish any books, you also can use these type of symbols in your specific article or maybe specific publications. So it shows your professionality. Okay. Mostly these type of symbols are presently used in government related documents or public documents, which was published by any one universities or any government bodies. Basically, the private parties are not actually highly preferred this, but especially the big corporate companies like Infosys, Wipro, IBM. So they are still following this type of symbolic representations. Each and every symbol will explain some different meanings. See, that's what I try to categorize here. So copy and published. So attribution, commercial use, modify, change licenses. So I think it's self-explanatory. If it is in the first, if the first symbol was applied, it means that particular document have copyrights, but the copyrights holder allow you to do anything with that particular document. So you can copy, but at the same time, you should give the credits to him. You need to clearly mention this particular document was prepared by this particular person, like our reference in our research journals, or maybe research articles. We always give reference, right? I quote it. So you need to quote it. You can commercialize. You can use this particular document, and you can credit to you can give credit to him, and you can commercialize it. No issues. So you can modify. So that's what we did in normal research works. So we read some articles, and we came up with our own understanding, and as well as we phrase it in our own way. Then we say this is what the statement was explained by this particular author in his particular article. So we are simply modifying the existing statement. Okay, change licensing. So even though we modify the existing statement, we can get license for our own article because that article was written by us. In some cases, even though you give references, or maybe even though you quote that particular article detail, you can't get the copyright access for those articles. Especially, I forgot that university name. I think it's a Lincoln University. I forgot that name. Actually, they have some prefix. I'm not sure. That university called the Lincoln University. It's in USA, and another one university in UK. These both universities, just for an example, I don't know how many other universities also doing like this. These both universities have open access libraries, so where they are offering mini research papers and articles. You can check those articles, you can use it for your reference, and you can quote it in your research papers or maybe research works, but you can't get copyrights for the research work which was done by you, because you are using their actual research in your research paper, so you can't get a copyright for it. It's complicated, I know, it's a little bit complicated and confusing, but actually the IPR is actually framed like that. It's have too much of confusions and complications. So according from the university, what they say is, we are sharing this information for just make them to gain knowledge. So we can't allow them to get the ownership of this particular article, or maybe any small part of that article. That's what the logical argument is placed by the university. Still, actually, the court was favor of that particular university. So you need to be make sure while before doing anything like this. So whether you are able to commercialize it or not, whether you are able to modify it or not, so whether you need to give any attribution to the actual author of that particular article or book. So whenever you try to get reference from any of the existing works, always keep it in your mind. Always check it before proceed anything further. Okay. So these are all the things. Actually, I think it's self-explanatory. Based on the visual, you are able to see it. Whether you are commercialized, it's open. So what type of holdings they might have. So I think everything is already explained. This table is commonly called as Creative Commons license. Okay. So now we are getting into the patents. So anyone have any idea how many patents are available? How many types of patent rights are available? Anyone have any idea?
Pretty much.
Okay. Anyone else?
Patent. Patent.
Okay. Let me proceed. So it's an AI generated things, my dear friends. That's why something is different. Some of the statements are a little bit different. So I don't have time to correct everything. So I'm sorry for it. Okay, let me proceed further. So there is many types of patents are available. Nearly 8 different types of patents are available in the existing patent markets. Not only one. There is totally 8 different types of patents are available. So whenever we are talking about a patent, so yesterday I think one of our participants actually raised a question, sir, I have this type of thing, whether it's valuable or worth to apply for patent. So why actually we have this confusion? We don't know what all the different types of patents are available. There is totally 8 different types of patent rights are available in the patent market. So it's our own responsibility. Yes, any questions?
No, sir.
Okay, fine.
Just coughing on.
Okay, sure. So it's so we need to take the responsibility to find the right patent model for our particular patent application. So then only you can strongly argue with the patent officer or maybe argue with the patent expert to explain your product or service. Most of the time, definitely they will get confused. I'm strongly saying definitely they will confused, or maybe you will become confused. So sometimes you might have a design pattern, but they will take it as a utility pattern. Sometimes you have an utility pattern, they thought it's an architectural pattern. So there is too many different confusions might be possible, because what type of value you are applying for that pattern, it's also affect if you are applying in Chennai or you are applying in Delhi. So in which patent office you are approaching, their perspective also might different. So they are dealing with different types of patent forms, so they will expect the same type of patent form from all of the applicants. So it's not going to be applicable for all. Okay, so first you need to be make sure what type of patent you are dealing with. First one is design patent. This is a common patent type. We are designing something. Especially, I repeatedly says you are came up with some form of new solution for the existing problem. Okay, you are solving some problem, you are came up with some new codings, you are came up with some new concept, so you are producing some new design. So those are all the things comes under the category of design pattern. So definitely it will make you a little bit confused. Just stick on with me. So once we see the remaining pattern types, you will get the clear picture. Here it's actually mostly suitable for computer programming, but so it's an legal term. It's they says that it's mostly suitable for computer programming. Even some other pattern models also, they think it's suitable for computer programming. So that's why. So we need to be very strong and we need to be ready to argue for our own concept. Okay. So it's not only for the computer programming. So you can, if you came up with any form of design related idea, even I think most of you know about Starbucks. It's such a franchise models of a coffee shop, right? You know, Starbucks holds thousands of patents for each and every unique models what they have. Even the coffee cup which was made by Starbucks holds around 30 plus patents. Even the crinkles, the size, the holder, the cap, the open nips, everything was patented. Actually, I don't know why they are actually file a patent for separately for each and every component, but they have some reasons behind. So that's why they file any number of patents for their different products, even though it's an international patent, not an Indian patent. So those are all the things comes under design patent. So no one copied those type of same patent model anywhere or anymore. Okay, that's called design patent. Next one is utility patent. Your product have some form of utility, some form of specific functionality, then you can go ahead with this utility patent. So in some cases, your particular product can make the existing process faster. Okay, so or maybe simpler, easier. Those type of utility functionalities also can be patent. In some cases, you can get patent for both. You can get patent for design, you can get patent for utility. So yeah, so I already give an example of the Starbucks, right? So in Starbucks cups, they have both. They have their design patent, but not all design patents is valuable to consider for utility patent. But they also have some utility patent. So best example, my dear friends, actually, Starbucks cups, they try to wrap up their cup with some cardboard material, right? So we may think it helps us to hold the cup properly, but it also function as a thermal protector. So the cup might be too hard, so you can't directly hold the cup with your bare hands. So what they did, so they create some form of cardboard wrappers for their cup, so which is actually cut down the size, match with your hands. So if you hold that cardboard wrapper, it functions as a thermal protector, so you won't feel that hot, but still the coffee is hot. So this thing have two types of functionality. One is design. First, the design is unique. Second, it has some specific functionality. It functions as a thermal protector, so it has some utility. Okay, the functionality here, it's called utility. It have some specific function to serve. Those type of things also can be patent. Okay, that's called utility patent. Starbucks got patent in both types. Even actually they got patent for the entire process, but for this coffee cup, they have design patent. They also have utility patent. Okay, so next one is architectural patent. I think any of IT faculties are here. Can tell me what is called MVC? IT or CS faculties? In programming especially. Okay. So fine. I think today is the interaction seems like a little bit lower. I don't know what, because it might because of the topic, or maybe it feels bored. So do you feel bored, my dear participants?
Yeah, but it's
No,
it's
no,
theoretically
sir.
at the same day. That's good, but it's little
No,
theory, but
sir.
it's okay, sir. It's okay, sir.
No.
Yeah, here, yes,
Sir,
yes.
I think IT faculties are not here, sir.
Okay, fine. But however, I'm sorry because of this concept. It's actually like this.
I
So
know that we know. Yes, sir. Yeah, absolutely. Yes, we understand that. Yes,
it's new.
yes, sir. No
Most,
problem, sir.
most of us,
okay.
it's new. That's it.
Okay, because yesterday I make it as a story, so it's actually a little bit interesting. So this actually that's
Yes,
what my own terminology. So whenever I take in class, I try to keep it mostly as a story, so it will make you engaged and it will make you interesting. But however, it's my responsibility to cover the key areas to you, right? So
I know, sir. Yes, sir.
that's why it's little bit theoretical. That's why it make you feel little bit bored. But however, stick on with it because it's too important, my dear friends. Whether we like it or not, we need to mark up
Yes,
something and we need to vomit something in our examinations like that. So that's what. Okay.
yes. Okay, sir.
So Now we are in the form of architectural pattern. What is called architectural pattern? Here I give an example like constructions, because whenever we talk about architecture, we always think about engineering, how they are actually architecting the buildings and the bridges and many things. But architectural pattern is not only applicable for construction, even the construction. So how you are constructing a computer program, it also can be patterned under this architectural pattern. So at the beginning, I asked what is called MVC. It's model view controller. Who are all not belongs to IT or CS, don't get too much confused. So it's just for your understanding. I give it as an example to you. I will explain you what it is and why we are call it as an architectural pattern. Okay. So model view controller. Actually, they segregated the software programming into three different phenomena. One is model, and another one is view, and another one criteria is controller. So whenever you want to create a simple computer programming, I'm a programmer also. I'm a web developer and as well as app developer. So I know what is the actual basement of program development. At the very beginning, whenever we writing in program, so if you want to develop a simple computer application, you need to write tons and tons of codes. If you find any one error, definitely you will feel terrible to fix it, because you can't find where that particular error was occurred and how it's actually reflected and how the chain of actions was happened to. It's called bug fixing or error fixing. It will take much more time than the actual creation. Such a damn thing in programming. But once we implement this MVC concept, model view controller, we are segregating the actual programming into three different categories. First one is model. What is the basic functionality? What is the basic model of this particular application? It's separate. View. What the actual user going to view? The front page, HTML or CSS or JavaScript page, the basic function, the front view. Controller, which is going to function as a connecting platform between the front view and the back functionality, the model. So they separate everything. So nowadays, what all the maintenance function was made by that particular company, as a user, front-end user, you can't see any type of differentiation in their functionalities because your view always remains stagnant. But at the back end, they can develop anything what they want. They can reverse engineer anything. Okay, this is called server downtime. Mostly these days. I don't want to get into too much technical. So why I'm explaining this much deeper is this MVC architecture in programming is such a great invention, not an innovation. It's such a great invention which makes the programming much more easier. This is called architecture. The person who is actually inventing this MVC programming into the programming field, it's a great architectural model for programming to make the process easier. So the same way how the building was constructed, the same way the programs also can build. Those type of things can be registered under architectural model. Okay, I try to give the example, but on day-to-day use case, you will be able to know that. It's okay, so you can't able to understand everything within one day or maybe within one session. Definitely, it will take some time for you to grasp the things. Okay, just try to remember the things. So whenever you notice different, whenever you came across different case scenarios, definitely you will understand what it actually talks about. So next one is integration pattern. Integration pattern in the sense, nowadays we are actually living in the era of, already I repeated, AI, but there is another one concept called IoT. So anyone know about the IoT?
Internet of Things.
Thank you, ma'am. So Internet of Things. We are living in the field of Internet of Things. Actually, it's not new for us. When the Alexa was introduced, the Amazon, what is the device was? I think Amazon is Alexa. Yes, Alexa and Siri was introduced. The entire home automation become boom. So you can turn on lights, you can turn on your TVs and refrigerate, sorry, air conditioners. So through your mobile devices, everything was automated. Everything was connected through internet. So the entire ecosystem was become online. Okay, so even if you want to turn on your motor, which is located in your farm area, just you can send some message, it will turn on the motor, right? So if you want to turn it off, just you can turn it off from your mobile. Even it might be a black and white mobile, just through sending in some text messages, you can do it. How it became possible? So those different types of electronic devices was synchronized, was connected with some form of technology. It actually integrated with the concept of IoT, Internet of Things. So it's actually a little bit technical. They might have some form of they have some form of devices, Raspberry Pi like that. So we don't need to get confused on the technical terms. But the thing what you need to understand is each and every electronical component was integrated with each other electronic devices. Basically, it's integrated with internet. So it get the commands from that internet. Okay. So these type of integration is not an easy task. In other cases, integration also can happen while you are migrating from one type of database or one type of programming to another type of programming. So I don't know how many of you know that recently Google Google fired around 36,000 of their Python developers. We all know Python is an trending programming language which is going to replace the entire programming area, but Google decided to fire around 30,000 plus Python experts from their team, from their company. Why? Simply Google hire another one AI to replace the Python programmers. They came up with a new idea which can integrated the actual manual Python programming to a system Python programming. So once that integration process was succeed, they simply fired the entire employees. As well as Google file integration pattern for that the integration application what was developed by Google. Okay. So when the thing is migrated from one form to another form, it's also called as an integration. Or maybe when multiple concepts was connected together through electronically or conceptually, it's also a concept of integration. So that's what the previous project I told you, right? Collaborative activity. It's collaboration, it's another form of integration. Okay. So, but it's not worthwhile to consider for patent. But if you invent something valuable like IoT, you can go ahead with this integration pattern. So I think we already hit 8 o'clock. Still, we have 3 more patterns, my dear friends. Just try to stick on with me for another 5 to 10 minutes. So I try to finish it as soon as possible because these are all the things definitely you should know that. So UI UX design pattern. So UI UX is an especially for mobile applications and web applications. How that particular website or application is visual to you, how it's actually appealing. What is the color? What is the font type? What is the ratio? What type of aspect it actually aesthetic look it's actually have? Those are all called designs. That's called UI UX. Anyone heard the term golden ratio? Anyone know about golden ratio?
Yeah, that's a camera related Fibonacci. That's a
Yes,
ratio.
yes.
Yeah.
So mathematically, they say there is
Yes.
an Fibonacci. Okay. Any other idea about this golden ratio? Okay. Actually, golden ratio was created naturally. It's our natural mathematical principle. So whatever you see, so the design was basically made by the principle of golden ratio. if you see any flower, if you see any one small bug, or if you see any type of animal, so it's basically have some natural golden ratio aspects. So why I'm talking about golden ratio aspect while I'm talking UI UX? It's not a simple thing, my dear friends. Each and every Apple iPhone icons was designed with the principle of golden ratio. They have some separate software for it. Your application icon should be 100% stick on with the golden ratio principle what they are actually followed. That's why Apple mobile phone icons are looking totally different to you. So when you are able to see, visually see it. Once you open that Android mobile, you are able to see those icons are a little bit different, not unique. But when you open an Apple iPhone, you are able to see in some way those icons are directly connected with you. It creates an psychological feel. Because I am a psychologist, I think at the beginning I already told you, I know I am a psychologist. From the consumer behavioral point, it actually try to connect with you emotionally, because golden ratio is a scientific principle which was provided by the nature. So if you utilize it, definitely your design will feel more reliable with the users or viewers. So that's why Apple company got patent rights, got UI UX design patent rights for each of their icons, each of their display designs, and each of their app icons. Even you might be a creator, but those patent rights was held by Apple. You can't get any patent rights for it. Okay, if you want to sell it in, so if you want to upload your app in Apple, definitely you need to give the patent rights to Apple. So they are very keen on it. So as soon as they are start applying n number of patent rights for their UI UX approaches. Okay, so that's called UI UX. How the digital devices, how the mobile applications or maybe web applications or maybe the website is actually appealing to you. How functional it is, what type of feel it's actually making. Everything was patented, can be patented under this UI UX design patent. So enterprise or business patent, this is what we already discussed. If you are a business person, so you can patent your ideas, you can patent your business models. So with the proof of concept, so you need to integrate and you need to come up with some different set of documents. So you can register your business models as patents. So okay, we have only two more. So data and AI patents. So especially we are in the era of AI. So AI is a functionality which has become possible through LLM, large language models. So the large language models have some huge amount of database. In other words, the entire internet, they store the entire internet, they process the data from that internet database, then they came up with their own solutions to you. It's just actually paraphrasing the existing results. It tried to combine the different websites and different source results, and it paraphrase those things, and it will revert back to you. How these informations was stored in their database, and as well as how the algorithm was deciding the connecting factor between different source of informations. This is called the data and AI pattern. Especially, so I don't know how many of you use Perplexity. So we basically use ChatGPT. So if you're not using Perplexity, I strongly recommend all of you start using Perplexity. So once you put the same prompt in ChatGPT and Perplexity, you are able to easily identify the difference between the results. Perplexity always given results with a reference, but ChatGPT try to give results as a simple paragraph. Okay, Perplexity functions like a research paper. It always try to come up with an proof. So because both LLMs, large language models, they store the data in a different structural way, and they process the data with the different types of algorithmical practices. So each can be patented. This is a 100% new form of patent which was introduced recently because of this AI boom. Still, it's actually don't have a strong legal framework, but still most of the governments are ready to accept it as part of the patent. Still, India, it's actually it's under debate. Still, they are not 100% ready to accept it. But if you approach through court, definitely they will agree. So this is a last form. So as a educator, we already know what all the types of material you prepared. It might be a document, it might be a book, it might be an article, PPTs, question papers, or anything you can apply for patents. It also has some amount of restrictions, especially the IPR still won't give patents for you for these type of documents, my dear friends. Okay, so these types of instructional designs actually. So as of my knowledge, it's just for namesake, but they are not providing any type of patents for any form of instructional materials. Especially, they will give these type of patents for any of the from the famous institution like IIM, IIT, Harvard Business School. So those type of institutions can approach this IPR cell for applying these type of instructional design patents. But otherwise, for a normal institution or maybe normal faculties, to getting these type of instructional design patents is not possible. Based on my observation, it might be simple in the future, but I'm not sure about okay. These are all the various types of patents are available. So thanks for stick on with me until 9, I think so. So as of now, any of you have any questions, you can feel free to ask. Okay, so yes.
Yeah, yes, sir. No, sir. Nothing.
Okay. So any feedback or any of your opinions? Because based on your feedbacks only, I am able to decide how was that section. How I'm able to identify. I'm able to judge how was that section. So how it is, what you feel. So I already say it's might be feels little bit bored, but the concept was like that. But what about your feedbacks, my dear friends? How it is? What do you think?
Only
Good evening,
just want
sir.
to get the AI. Okay, please.
Yeah,
Please,
Mubina,
please,
Taj.
please continue.
Yes, sir, the session was really very informative, sir. We had something new to learn, the patterns and all. We have never come across all these patterns and all. So it was very informative and engaging session that what we had today, sir. Thank you for the session, sir.
Thank you, ma'am. Thank you. Bijo, sir. Okay, anyone else? Yes, yes, ma'am.
Father Vijay, dear participants, if you have any queries or any comments, please feel to ask.
Sir, good evening. I just want to the we all speak about AI and all now, and that is actually a big challenge nowadays. Everyone faces that actually. All the areas actually. There's a lot of questions about the employability. Like, will the AI be replaced for human employment and so on? So more or less one or two. Can you just guide in the IPR? How is AI is will it be a challenge to go ahead with the content creations and so on? Like with the AI, there are when we speak about AI, there is AI assisted content and AI generated content. So in that case, could you please speak on that, sir? Just to
Okay.
AI and the yeah, please. Just
Okay, it's a nice
you know,
question, as well as it's
and it's a
should
big.
be. Yes, yes, it should be addressed, like, because it's such an important question. Thanks for raising this particular question. Because of this AI evolution, definitely this IPR going to be under questionable scenario. because it simply can easily paraphrase the things which was copyrighted, and as well as even it have the complete patent applications. So we need we discussed, so you need to go to check the websites what all the patents was already applied in these type of in your same field and era. So we need to search, but these large language models already have this entire patents within their library. The complete each and every corner of that particular PDF document was already read and analyzed by that AI model.
Oh,
So it can
yes.
easily came up with the knowledge gap among that models. Okay. So definitely in IPR perspective, this AI going to be really a challenging factor, but still the positive side of that particular scenario, so it can reduce our research load. So actually we need to treat that AI as our assistant, not our ruler. It just as a research assistant for us, because the one thing we need to remember, we need to keep it in our mind always whenever we deal with AI can only answer the questions which was raised by you. It can't think by itself. So, for an example, if as a business professor, I always face these type of questions from my students. My students say, "Sir, if AI will dominate the market, what we will do? If AI will change the business scenarios, what we will do?" These type of questions they mostly ask with me. My reverse question to those students are: see, my dear students, AI have entire data. So if you want, so AI can analyze the entire market, and it can simply say what type of products or what type of customers are already existing in this market. But what AI going to do with that information? It can't do anything. It may give some suggestions to other business owners, but that's what the model was actually developing. Anyone know about Google Max? Anyone heard about it? Google AI Max. Okay. So it's actually AI model which was developed. It's actually in the beta version. Google actually developing another one new AI model called AI Max, which is going to provide a suggestion to the business owners with the market information. So it helped them to make the strategical move among the business scenarios. So the thing is, AI not going to do anything. It can't do anything by itself. It only can function through your questions. It only going to answer your questions. Nowadays, even though from our point of view, from the beginning onwards, so getting a pattern, it's not even a matter. Okay, you can get n number of pattern. Even you no need to worry about the AI, man. AI, my dear friends. So you can just think about the agencies who is actually applying pattern for 2,000 and 3,000 rupees. I don't know what type of I don't want to use those words. What type of thing they are actually doing? Even they are getting an n number of patents. So, but what is the benefit of it? The same way through AI also we can get n number of patents, but what you are going to do with that patent, that's what actually make changes. So in that particular point of view, so we no need to worry too much about that AI. So it's not going to do anything with that patent rights. So there is no issues at all. So as a
Okay. Thank you, sir.
manpower, as a blind, it's always important.
Thank you,
Any
sir.
other question? I think someone raised their hands, I think so. So any more questions? Okay, I think the event organizers, they can proceed their things, please.
Okay, thank you, sir. Good evening, everyone. It gives me an immense pleasure and honor to extend a word of thanks at the conclusion of this enlightening session. On behalf of the organizing committee, Christ College of Science and Management, Malu, I extend our profound gratitude to our esteemed resource person, Dr. Baluswamy, for delivering 2 days of insightful sessions and sharing his expertise and perspectives with us. Sir, Your presentations have given us a deep understanding of the fundamentals of intellectual property rights and their vital role in encouraging invention, innovation, and entrepreneurship. Your clear explanations, practical insights, and interactive approach have truly broadened our perspectives on how ideas can be transformed into valuable intellectual assets. Thank you very much, sir. We are also thankful to our principal, Reverend Father James George CMI, for his constant guidance and support in making this program a success. A special word of appreciation goes to my fellow coordinators, Dr. P. Rajalakshmi and Ms. Nayana N. Nair, for their tireless effort, teamwork, and commitment for organizing this FDP. I would also like to extend our gratitude to Olivia International Publication, our knowledge partner, for their collaboration and support in bringing together such a distinguished panel of speakers for this program. A heartfelt thanks to all the faculty members and participants for your cooperation and active participation. Once again, our deepest appreciation to you, dear Dr. Balasamy, for your valuable time, effort, and the wealth of knowledge that you've shared with us. We look forward to more such inspiring sessions in future. As we come to the end of this day's enlightening workshop, let's take with us the message that innovation flourishes when ideas are protected and valued. Let's continue to create, innovate, and inspire with responsibility and awareness. Thank you all for your participation.
Thank you all once again. Thanks for spending this 2 days valuable time with me. So from my perspective, so time is much valuable than anything. So I thanks once again for all of you to spend your valuable time. So always try to keep on learning, keep on practicing, not only learning, keep on practicing the things. Definitely it will produce a huge amount of great results in your life. So thank you all. Thank you once again.
Thank you so much, sir.
Thank you, sir. Thank you very much.